Hello everyone, welcome to LexTalk World's talk show presented by Click of the Creators. Today we have Mr. Tushar Agarwal with us. Mr. Agarwal is a Amity Law School alumni. His practice primarily focuses on criminal law, constitutional law, and commercial arbitration. And he has been part of some of the most eyeballs catching cases in the Indian legal industry. He was one of the assisting counsels representing Dr. Shashi Tharoor in a famous Sunanda Pushkar Death Case. I hope you all remember that. And he has also appeared in few pro bono cases with senior counsels representing association of victims of Uphaar tragedy, associations of victims of Meerut Fire Tragedy, etc., and so on and so forth. The list goes on and on and on. We'll try to dwell down to his career, to his journey, and also would have some tips from him as a lawyer. But without further ado, let me first of all formally introduce you to the man himself. Hello, Mr. Agarwal, how are you doing?
Hi, thank you so much for a wonderful introduction. I'm very well. How are you doing?
I'm doing wonderful. Thank you very much, Mr. Agarwal, and I really appreciate you getting some time for us today to discuss or to share your journey with us.
It's
So,
completely
without
my
further
pleasure.
ado, I would it's our pleasure as well, Mr. Agarwal. Now let's dwell down into the details that our audience is precisely waiting for. If you can tell us about a complex, I'm just directly entering your practice now. So if you can share a bit about a complex legal issue you worked on, and if you can also describe the complexity around it. Also, if you can tell us how you really approached it.
Whenever clients approaches us, every client with comes that his problem is most complex one. So it's really a question to narrow down to only a one problem. But yes, recently I'm doing a case which I think I can give it as example the most complex situation. In a domestic violence case, where one the husband approached me, he hired me, against whom cases of domestic violence and FIR under Section 498A was filed. And the magisterial court ordered an interim maintenance order against the husband, where he has to pay a certain amount per month to his wife. So the husband, due to his ill health and severe medical condition, was unable to pay even earned for himself. So he was unable to pay any maintenance. But magistrate court failed to understand that. So meanwhile, when my client failed to do so, the other party approached the High Court in a contempt jurisdiction, that my client has committed a contempt of court. They have not complied with the court of magistrate court. So now in a society setup, which is very unfortunate, where it is being presumed that the husband must have committed domestic violence or a cruelty upon his wife. So some orders are being passed on such presumptions without considering the actual facts. So the challenge before me when I was hired, the contempt was already there. Even an order was there where show cause notice was already issued to my client, that we are prima facie of the view that you have committed a contempt. Now give us a reason why we should not issue a contempt against you and give you and punish you for that. So I took it as a challenge that my the approach should be, we need to really convince the court first of all that this is not a proper remedy to come before the court. If I have not complied with that order, you have a remedy of execution proceedings to go before the court. So the principle behind it, that you have an alternative remedy, you cannot directly approach in a contempt jurisdiction. It's a misuse of process of law. And also some appeal and everything was also pending before the sessions court before the client approached me. So since those appeals and everything are also not decided, so getting an issue in contempt will be abuse of process. So I put this thing in a written submissions before the High Court, and High Court appreciated my point. They said when you have an execution proceedings and you the your my client has already filed an appeal challenging that order, so it would be inappropriate to issue the contempt against him at this premature stage. So they sent us back to the court, and in that lower court, I try to make the judge understand that when this maintenance order was passed, So it was not an ex parte order, it was passed in presence of both the parties. So before passing an order, the Domestic Violence Act provides that if both the parties are there, you should allow us, both the parties, to lead the evidence and then pass any maintenance order. Because if in the end I pay the maintenance amount in compliance of that order, but in the end of the trial, you conclude that I was right saying that I'm unable to earn for myself and everything. So the torture and the agony which I faced during the entire trial, that will be completely unjustified and that cannot be returned back. So initially you should allow the lead the evidence and then should give. So the court has appreciated my point. So why I mentioned this, the complexity was there were already two orders against me for the maintenance. I have not complied with. There was a contempt against me. There was an execution proceedings against me. And there was the entire unfortunate mindset of the entire society was against me. But I approach that I need to convince the court by putting a clear picture without hiding anything and tell this is the abuse of process of law and this should not be allowed. But I got succeeded in that. So I guess this was interesting and one of the good achievements in my career, so that I could won something from the husband side, and which can help other people also, where these provisions are being misused, which is being reported also, that these female protective laws are being misused. So yes, this was the complexity.
There are some stats that say that women and so-called feminists are also using this not as a protective law, but not as an offensive one, not as a defensive one, but an offensive one now. So that's something happening. If I could dwell down to this, Tushar, more, I understand when you're on the other side of the coin, as you said, how the society is structured. When you join a party which is not supposed to be, or a client which is not supposed to be supported as per the society law, um,
Yes.
how are you looked upon? How do you handle those situations? Your family, your friends, or even around you. How do you really look into that?
See, in that part, we have to be a little bit professional and stick to our professional ethics in that. We need not to think about the society. Doing a criminal law, I face this situation where people say you represent a criminal offender. So the basic thought behind the normal person is that if any complaint or FIR is registered against a person, they consider him guilty at that point of time only. But we being the lawyers, we being the especially the criminal lawyers who are defending accused persons, we need to believe in two principles. Number one, everyone has a right to defense, which provided by Constitution of India. Ultimately, an accused is also a citizen of India. And secondly, being the law officers, we need to be fair to the court. If we are doing so, I have got results with these two approaches only. We need to be very fair. Yes, obviously, we need to tell the accused that you have to tell us the entire truth, nothing but the truth. So because if he has hidden something, he will definitely going to face the brunt of the court on that part whenever this thing will be disclosed either by the state police or either by the complainant itself. So yes, the when we meet friends, when we represent accused persons in famous cases like this, where the people are being cheated or people are being defrauded or there is a crime against those people, they say they feel us like with the hated eyes, hatred that we are representing an accused, we are opposing, we are also fighting for their bail. But yes, we do so in belief that if we are doing with all professional ethics and with all truth, if there is there are evidences, we believe in the criminal justice system. If the police has done the investigation, if there is something which is against us, obviously court will punish us. But if there is nothing, something has been manipulated, something has been distorted and presented before a court in an arm twisted manner. So, as a law officer, we need to be fair to the court as well as to the criminal justice system and represent our client to the best manner possible.
That's brilliant. And as they say, innocent until proven guilty. So that's a practice that
Absolutely,
everybody
absolutely,
follows.
absolutely.
Uh, we will of course come back to your key practice area and your some more renowned cases which I of course want to talk about. But before that, let's go ahead a year or 2 years back. We all saw pandemic coming, and in your case, you saw that in pandemic. courts begin moving towards more remote proceedings and availability. What do you think? Is this sustainable and a possible way to increase access to justice, in your opinion?
See, when in March 2020, frankly, when the pandemic came, the first wave of the COVID in March 2020, so I was also of the view that the courts are going to suffer a lot because, frankly, I did not believe that we will be able to develop any online system and such a flawless and strong system where the cases can be taken up and the judges who are used to read the files through their physical copies, they will be able to join. Because when we talk about a court on a video conference, it's just like that people think, or sometimes it seems like a joke also, that people are doing video conferencing like a normal Snapchat, a normal FaceTime and every like this thing. Because when we listen to the court, we feel that yes, judge is there is a decorum, and people are there, we need to present our case, we need to be in a proper uniform and everything. So yes, in video conferencing, that was a challenge, but I'm proud that within span of 1 week itself, there was the entire system in place where the Cisco WebEx platforms and Microsoft Teams platforms, and one was a Video Connect, other platform developed by some company, they was in place. So I think yes, the video conferencing, the pandemic has compelled us. The courts through video conferencing was the idea being floated for many years, but that was not implemented per se. But pandemic compelled us to do so. It told us the importance of technology in our life, and yes, the court can also use that technology to provide justice, because otherwise, if this technology would not have been there, the pendency which was already there, that must have increased to all multiple levels, which we cannot think of to dispose of in many coming years. It is also not a doubt that yes, obviously it is not a complete substitute, but yes, it can complement the physical hearing where the access to justice can be increased. And yes, the question comes as before me also, where that like small cities, like I belong to Meerut, I have seen the situations in Meerut, which is a small town of a UP. There is no good internet, no good systems, and even the whatever budgets must be sanctioned to the courts to arrange all these, those must be low. We are talking here sitting in Delhi, Bombay, Calcutta, Hyderabad, metropolitan cities. We are talking where there are a lot of funds are also there and lot of technology is already there. So yes, that's why I've said it's not a substitute, it should complement. Yes, but we must invest in small cities also, so that nowadays, if we read some research, the smartphone penetration in India is the maximum across the world. Every small vendor, small person, employee, labor has a mobile smartphone nowadays. The prices of the smartphones are also decreased to such level that small people, poor people, rich people, every class of the society can access those smartphones. So yes, instead we should take an initiative. The bar associations of those district courts should take an initiative to teach lawyers or even judges. The training should be there, that through smartphones or through some devices, laptops and everything, where it is possible, we should do some we should rely on these video conferencing at least for some kind of cases. Like I have seen arbitration. In arbitration, sometimes a situation is there, the arbitrator appointed is sitting in one city, the state claimant is sitting in another city, and the respondent is sitting in third city. So in physical hearing, what used to happen is they have to collect on a one place where the arbitrator is sitting. Now through online, wherever you are sitting, you can conduct the arbitration. Otherwise, there used to be a lot of adjournments in arbitration, that sometimes claimant is not available, sometimes respondent is not available, sometimes his flight is being cancelled. And this time, the purpose of arbitration is solving the problem more faster than the normal litigation. But now this, with this video conferencing, wherever you are, you just join the conference, you just present your facts, and you have the judge, the arbitrator just has to ensure that everything is being done in a proper code, decorum and formal manner. So yes, I completely believe it has increased the access to justice. It cannot permanently substitute, but yes, some kind of cases can completely be online, and it should continue. The like in Delhi, I know in many other cities, I know the hybrid mode of the court hearing has been allowed, where if in today also, where there is no restrictions as such, if we are not able to appear physically due to some difficulty, we have a remedy to just file an application one day in advance that we want to appear through online. And the high courts and Supreme Court has directed all the courts that their link will be opened, video conferencing link will be opened from morning 10 till the last hour of the court working, 4:30 here in Delhi at least. So whenever a lawyer joins through VC, he should be allowed to present his case.
That's right. I mean, very rightly said. And as you said that it for you it sort of increases the access to justice, but at the same time it's also about infrastructure that is that is more needed in
Yes, we
tier
need
two,
to
tier
work on
three.
that. That I agree. We need to work on that.
Brilliant. Uh, um, Talking about pandemic, and we cannot leave technology behind it. And in pandemic, we saw a lot of disruptions happening around us. Maximum startups that pulled in a year, maximum number of billion-dollar startups, the unicorns that India had, and legal tech emerging. Ironically, a pandemic gave us some good things as well. In the era of technology, rather, I should say legal technology, what are the most commonly used tool for you? I mean, for you or by you?
Yes, I completely agree. During these days, during the pandemic, also the use of technology and was became very important. Lot of firms and lot of companies completely went on a concept of work from home. They have not even returned back to their physical offices. They have closed the concept of physical offices. They are working from home itself, because after pandemic they have realized that working from a whole setup of office is more costly. Instead, you provide infrastructure at home of that employee, and then you start working from home, and they have got good results also. If we come down to legal fraternity, legal era, where the courts were completely physical, they have not faced such things. So legal tools, number one, the importance of a good technological setup in your chambers. For example, I did not have any video conferencing room per se, cabin in my offices. So I need to have a good video conferencing facilities to be in place. But if we need to be present our case in a proper manner, I have seen lawyers which have set up the things in a manner that they set up the televisions or video conferencing facility in such a manner that they, even in their offices, they stand on a podium and then present the case. So the court should feel that I am standing on that podium and representing a case. The distance is such which is in a physical manner. In their offices also they have developed this thing. So yes, number one, the video conferencing facilities, a good internet facility, VC platforms, you should be aware of. I myself got a training from my cousins who are good at IT about the platforms like Cisco WebEx or the Microsoft Teams, because I didn't know that how we can create an account there, and how, most importantly, how we can share the screen per se. And on the Zoom or itself, that we can share the screen, we can share the music and everything, whatever. So for me, sharing a document, then a highlighted document, and even if we can bookmark that document and everything. So I myself took in training. I got my colleagues and my clerk trained for those technologies, so that everything for the first time completely e-filing was there. So even the clerk who are responsible for filing, they were not even aware about how to do e-filings. We need to get them trained. So yes, there's a training for those technologies. So we hired, consulted with the IT people who trained us. So nowadays, the important tools would be, you should be well aware about the video conferencing platforms. Everything, you should have access to all those, because across India there are 4 5 video conferencing platforms which are being used. Cisco WebEx is the most common, yes, but there are 4 5. So you should be all aware, because this pandemic has given us opportunity that even sitting in Delhi, we can appear in High Court of Chhattisgarh, High Court of Bombay, High Court of Gujarat. But if they are using a different video conferencing platform, and the hindrance which is coming is that we are not used to that video conferencing platform. So I say that is very unfortunate. because just of that we should not be able to represent our client that we are not aware about that video conferencing platforms. Yes, importance of, because of the e-filing, importance of various good document editors have increased, like PDF editors and everything. That tool has to be there with your office. Every court has made it compulsory, at least in Delhi, about the bookmarking of those documents. So you need to have a good document editors in your place. And yes, obviously the good legal research portals like SEC, Manupatra and everything, you need to have access there if you don't have, because now the trend of having bulky books behind your, if you can see behind myself, my shelves are very light, because everything research portal has complete on the laptop. You just enter your user ID password, and every judgment which are there in those books and everything, that is on your laptop, and you can then take a printout or highlight. If you have a video conferencing, you just highlight the portion and screen the share and present your judgment and have your arguments before the court. So yes, strong legal research portals. So ultimately, whatever these 3 4 legal technological tools which are important for presenting your judgments: number one, the research tools; number two, the filing tools, document editors; and number three, these video conferencing platforms. So you should be well versed with all these things, and everything should be well in place, so that even now there is the thing are going that cases of COVID are increasing in Delhi. The Delhi High Court has issued that if the counsel wants to appear through online, judges should promote the hybrid hearing and everything. So even if unfortunately it should not happen, but even if we go back to the same phase again, so we should not be handicapped that we have not the system in place, and we are not able, either we are taking a date only, or we are unable to take up our the cases of the clients across all India.
So far, Tushar, this is going a very beautiful session. I mean, you're sticking to the very basics, and this is what everybody has to understand. You know, the way you distributed in three sections: research, documentation, and finally video conferencing. These are the basics that one has to go for. Uh, Brilliant. Now, having said that, as I mentioned, we'll again circle back to your practice areas. Uh, Although I've tried mentioning them in the initial phase of the session, but I would love to hear what is your major area of practice from you, and would you like to share a few important and landmark cases? You've shared a recent one, but few landmark cases being handled by you and your chamber.
Yes, yes. So as far as my major practice area is concerned, it's primarily criminal law, I would say. And in criminal law also, particularly the niche area which my chamber handles is the economic offenses and white collar crimes, which are being investigated by Economic Offences Wing, Central Bureau of Investigation, Enforcement Directorate, Serious Fraud Investigation Office, Director General GST Intelligence. So these are our Directorate of Revenue Intelligence, Customs Authorities. So these are all the investigating agencies which are in there, which are responsible for investigating white collar crimes and economic offenses under a particular statute, which has given them the powers to investigate those particular offenses and cases. So this is my major practice area which I'm on focusing. Even I did all my apprenticeship, internship, and all my trainings in this law only under good seniors and judges. As far as the important cases which I consider landmark cases which I have handled and got an opportunity in a very short career of 6 years in this legal profession, I was lucky enough, I would say. Number one, you have already mentioned about that Sunanda Pushkar death case that was being handled by one of my seniors under whom I was taking a training and everything. So I was hired as a briefing counsel to brief my senior. So yes, that was a case regarding which even a small development used to be published and used to be broadcasted in media. Whenever, even if the accused, I mean here Dr. Shashi Tharoor, even he is there or not, even if a small hearing is there for a small purpose, the media used to be there every time. So yes, that case taught me that you have to be very sensitive about these such celebrity and famous cases, because sometimes the input about the legal proceedings used to be taken from me directly. by the media people, not from my senior. So whatever I'll say, that is going to be published in broadcasters. So I have to say everything in such a cautious manner, so that nothing distorts the case of my clients and nothing goes adverse against my client, because sometimes it happens in celebrity cases, the media trials starts happening at a parallel side. So we have to be very careful. So yes, that is one of the landmark cases I have handled. Secondly, a few pro bono cases we have already mentioned about association of Uphaar of victims tragedy that happened in 1997 in Delhi. That's one of the very landmark cases where the complainants victim association got successful in getting the offenders punished, where the 59 people got lost their lives because of the bad planning of that cinema hall and no clearances for fire department and everything. Since I mentioned I'm handling the economic offenses, so yes, the white collar crimes famous cases is one of them is DHFL Divan Housing Finance Limited and UPPCL Uttar Pradesh Power Corporation Limited. So in the ED and a CBI has investigated a case and alleged that these two companies in together have committed a fraud of around 6,000 crore rupees. So that is also one of the landmark cases I'm handling, where I'm representing the secretary and the chairman of the TUPPCL. So we are handling that case. One case I would like to mention about Bhushan Steel financial fraud case. That is also a case being investigated by ED as well as Serious Fraud Investigation Office, where the alleged fraud money is running into around 24,000 CRs. So the vice president finance of Bhushan Steels are my clients. So that is also a case which remains into the highlights and the newspapers. And one case is last case I would like to mention is the Noida Ponzi scheme case, scam case, where around 650 CR scam was reported. If you must have heard, the scheme floated was about the digital promotion, and people who used to hire those packages, they used to give an incentive for doing a single like or subscribe. If you click a single like for their channel, so you will get some rupees, some incentive for that. So if you buy a package and for every click you are getting something. So a lot of fraud was reported there. So the MD and the director of the company against whom this fraud allegations are there, so those are my clients. I'm representing them in Supreme Court as well. So yes, these
Mhm.
are few landmark cases I think I'm handling, and I'm lucky, and with God's grace, I am able to get these cases at such a short span. So yes.
Brilliant, brilliant, Tushar. Before I move on to, I had, of course, a planned question after this, but something came up to my mind about media trials. Uh, how do lawyers handle? Can you use it in your favor? Does it always goes against you, or does it even affect you? You know, the media trials, because after all, you're also human. You know, you see your face or your case being handled by media who is talking about some alien crap at the same time, and then an intellectual case on the other side. How do you really see that?
See, that's a when you handle a highlighted case, especially where I mentioned this fraud schemes. So, when you represent a client and accused who is a director of a company against whom allegations are there that he launched some Ponzi scheme and siphoned off thousands of crores of rupees of the general public. So obviously, when you represent that client on opposite side, you have thousands of investors against you, with whom even the sympathy of a public is there, sympathy of media is there, and sometimes even with that sympathy in media trial, we have an apprehension that the court might also get affected. But yes, in that case, as I one thing I earlier mentioned, that we need to be very instigative and very angry or very anxious about this thing. We need not to state any such statement in media which can be misused against us. Sometimes our anxiety goes against us. We get affected by these media trials and publication of news and everything, which can hamper our client's case, obviously. But pursuant to that, we should not give such statements or such other reactions to those media newses. because ultimately whatever we'll say, that will be interpreted, manipulated definitely in different newspapers, different publications. Whatever we'll say, whatever we say, that is not going to come in that exact manner. So we have to be very careful about that. Secondly, with the passage of time, even the courts of law have noticed that this media trial is against the basic principle that guilty until proven. So we need to be in criminal law, we need to believe in principle that till the accused is proven guilty, he is innocent. So courts of law have taken cognizance of that facts. And lot of writ petitions we have also filed in the case of Dr. Shashi Tharoor's case, where there was a media trial going on. So we filed an application where we got a interim injunction order that all the necessary and legal papers of the case will not be shared with any third party who has no interest in this case. And the third party front includes all media houses also and everything's also. So there are remedies. Instead of giving provocative statements in the media and elsewhere, we should, being a lawyers, being the law officers, we should approach the court with appropriate remedy. And there are examples where the injunctive orders and gag orders are being given against the third party fronts and media fronts, not to discuss and not to publish the sub judice case proceedings in the media papers. So I guess we should believe in law, stick to the law, and approach the right forum instead of going to media and say your plight and everything.
That makes sense. That makes sense.
Yes.
Uh, Coming back to uh, your specificity of major cases. Uh, as you said, since your major cases, major practice area, I would say, is criminal law, and that too economic offences, precisely. What do you think about the latest judgment delivered by Supreme Court regarding provisions of the Money Laundering Act? Because
Well,
we are also talking about money laundering a lot.
yes, yes, yes. Even the money laundering has become a thing nowadays. It's just initially the concept of money laundering was the word, if you must have a laundering. It's related. It has derived its origin from word laundry itself. Like we give our clothes to laundry. So the concept is behind that money is being laundered in such a manner that from black to white, white to black, and just like this thing. That's why this concept came. So yes, obviously this term has become more very prevalent in the common society itself because of a lot of cases being investigated and reported every day. So that's an interesting question. I would like to comment. So yes, this was a very important judgment has come for particularly for this Prevention of Money Laundering Act, where the Enforcement Directorate is the investigating agencies empowered to do all the investigations, arrests, seizure and search and attachment of properties. Every power is there. It was a long-awaited judgment which a three-judge bench of Supreme Court has given. So, two, three questions which were being challenged, or the constitutionality of those provisions was challenged, were the arrest power of the ED, and what's the definition of money laundering, what kind of properties can be attached, whether the statement given to enforcement direct officers can be used against that accused persons, whether the document, the initial document, like in normal criminal cases we have FIR, the first document of the crime. In ED, prevention of money laundering cases, we have ECIR. So it's akin to FIR only, the first initial document on the basis of which they start the investigation. Yes, so whether to, as of now, the copy of ECIR is not being provided to the accused. In case of FIR, it is a law, a settled principle of law that within 24 hours of registration of FIR, accused is entitled for the copy of it. Because we believe that whatever case is against him, he should be provided with each and every document at an appropriate stage so that he can make a good defense before the court. Nothing should be hidden from him. Then only a best defense can be presented. So that was the akin to that principle. This was claimed that ECR copy should also be given. So these were 4 or 5 questions which were given. Like Article 23 of Constitution of India says that an accused cannot be given or cannot be compelled to give any self-incriminating evidence. So like any statement given to ED, as of till date, the law says that any given statement given to ED is permissible in the court as an evidence. So that was challenged before that court, that it cannot be used against the accused. Accused cannot be compelled to give a evidence against himself. So these were the
Just to add here, Tushar, I'm really sorry. I guess
yes,
this is not the case when it comes to giving your statement to police. I mean to the local
yes,
police,
you are
that
right.
is.
You are exactly right. That's why, pursuant to that, the statement given to police is recorded under section 161 of CRPC, and that is not admissible in the court. But
Mhm.
the statements given to these special agencies and the special acts, we are talking about Prevention of Money Laundering Act. So statement given under section 50 of a PMLA Act to the ED is admissible in the court. It has a admissible evidence value before the court. So that was also challenged, that ultimately on the basis of that statement where you compel a accused to give a statement against himself, that is a violation of Article 23 of Constitution of India as well. And when a state ED is just like another investigative agency, like a police itself. So the statement should not be used against the accused like 161 statement before given the local police. So these were few questions before the Supreme Court. So ultimately, Supreme Court has upheld the constitutionality of every provision, citing the gravity of offense the money laundering offenses has these days. And they have analyzed that the intent behind these provision was to secure the sovereignty and integrity of India. So these stringent provisions are necessary in place to bring the accused to the books of law, and whatever money is being laundered and whatever loss has been taken place to the exchequer of the country. So that should be investigated properly and the accused person should be punished. But yes, if you, I was reading one of the articles of a retired Supreme Court justice. He was recently retired in June, Justice L. Nageshwar Rao. So he also said in a manner that I will not criticize the judges or Supreme Court who have given the judgment. But yes, if I would have been there, I would have given a different view. So I would also go in the same line. If I would have been there, I would have given a different view. Few provisions like arrest powers and everything, the challenge was made by the accused persons was because these principles ultimately are against the very basic principle of the criminal justice, which I have earlier also mentioned, that accused should not be considered guilty unless it is being proved before the court. He should be considered innocent. But there are certain conditions in the PMLA Act which compels even at the stage of bail itself that accused has to show prima facie that he's not guilty. So ultimately, at a very initial stage of a bail itself, you are asking an accused or a court to conduct a mini trial to see, because if you have given a judgment at a stage of bail itself that if your bail is rejected, that prima facie I feel that this person is guilty, or prima facie I feel this person is not guilty, ultimately you have given a decision of a trial. Then what happens at the end of a trial? At the end of trial just says this only, that after considering all the evidence I feel found this person guilty, or I does not found I do not found this person guilty. So at this stage, very initial stage, this kind of stringent condition to compel the accused to say that you prove you are not guilty, per se, according to me, is against the constitutional principles also, the right to personal liberty under Article 21, which were challenged. Secondly, I am of the personal view that copy of ECI, the Supreme Court has said that ECI is an internal document of the ED and it cannot be compared with the FIR and it cannot be provided to the accused. So I have a little different view to take. If the document on the basis of which you have proceeded against an accused, you have taken a reverse action against an accused. So accused has every right to have access to that document. Otherwise, at the time of taking bail, anticipatory bail, and anything, any relief from the court, even the defreezing of accounts, because during investigation, the accounts of the accused companies and accused persons are being freezed by these companies to prevent the siphoning of the alleged proceeds of crime. So if we want the defreezing of that, so we need to know the basis. Ultimately, everything comes out during the court proceedings when we approach the court. When the ED files the reply, then we start getting the documents. So we approach the court on a half-baked material because we are not being provided with that material on the basis of which we can fight our case on a better footing. So thought, according to my personal opinion, ECI should be provided to there. But yes, one good ray of hope has come in this judgment in the aspect that ED is entitled to do and investigate on the basis of a predicate offense. Predicate offense means an offense being registered by an agency at first hand. For example, an FIR under ED has a power to investigate under scheduled offences which are given in a schedule appended to PMLA Act. So, any agency like CBI or local Delhi police or Mumbai police, any police per se, if they register in a case under a scheduled offence, so on the basis of that FIR or that case, ED has a power to start its own investigation. So the first offense registered is considered as a predicate offense, and the ED has a power to investigate and file its charge sheet and prosecution complaint on the basis of that first case. So Supreme Court has come up, gave a clarity, and this is a good relief for many accused persons. We have started raising these objections before the court also now, that if you are being acquitted in the predicate offense, then the ED cannot continue its trial. Why? Because ultimately your basis of investigation was that particular predicate offense. And if the court has discharged you or acquitted you under that particular predicate offense, then you cannot say that money laundering is still there because your basis has entirely gone. So yes, this clarity has come, which was not there. There were some cases where in predicate offense people were acquitted or discharged, but they were facing the trial before the ED. So this is a good hope. So I say this is a kind of law which will continue to develop with the coming times, with the new kind of cases, investigations, and with the senior counsels who have assisted Supreme Court in this case also. So they will continue to assist being the law officers to Supreme Court. We being the law officers will continue to interpret the law provisions and present in a better, fair, effective manner to the court, that this can also be the interpretation. Ultimately, the judiciary is to interpret the law. So we, being the law officers, have a duty to provide a holistic view, that before a judge takes any view, these two, three interpretations are possible, and according to us, this is the best possible. So if we only will assess the judge in an effective manner, then only a good effective judgments can come. So it's a black, white, gray, both kind of all three kind of judgment it is. It has some reliefs also according to me, and it has some areas which requires reconsideration, but yet it's going to be developed, and some relief and some other interpretations are going to come in future times.
I mean, yeah, that's right. I mean, I heard a lot of debates around this when it was happening. It was a very heated case, and not from a lawyer. We were all listening this from the spokesperson of different uh,
True,
organizations, if I may call
true.
them. So this is a perfect angle to look at it, and I guess our viewers and I myself had a clear view on what was happening and what came out of all of it. Because generally we know what was happening, but what is the result we are generally not aware. Uh, I guess we have taken a lot of time of yours. I just have two more questions, and then of course
Yes, yes,
I'll
pleasure.
leave you on your own, Tisha.
No problem,
Uh,
no problem.
in this, I really appreciate that. In view of increasing pendency of cases, you also address this case. If the courts would have not been proceeded with the e-hearings, then the pendency of cases would have been multiplied to I don't know what X levels. In
Yes,
view of
absolutely.
increasing pendency of cases and late delivery of justice, how do you think that the belief of a victim of crime can further be strengthened in the criminal justice system of India? This is a very common thing to understand or ask.
I agree for that, and it's a very important issue which needs to be addressed here also. And I would say that this issue can only be addressed when every stakeholder in the criminal justice system it will do its job with utmost sincerity and honesty. Stakeholders, I mean, in a criminal law, there are different stakeholders. Like police is one, investigating agencies, complainant who is the victim is second, the accused is the third, and the state prosecutors and the judge ultimately who is going to deliver the judge. So like if we say, if we need to believe, because why the belief of a victim gets shaken if he gets a late justice, because for lawyers, for judges, for state prosecutors, and even for police, there are multiple cases to handle. For a victim, it is the only case for his life. That's why the victim is the most sensitive about that particular case. He or she has the entire focus on that particular case. We being other lawyers and the police officers and judges have a lot of cases to handle. It is not a one case cannot be a special for us. For us, we need to deliver justice, or we need to make an endeavor to get justice for all of our clients. But yes, victim, if the belief of victim will not be there in the criminal justice system, so that will be the darkest day according to me in the history, because ultimately people go before the court that whatever justice, whatever decision would come, they either they believe, otherwise they will appeal to the court. But yes, they go with a hope that they will get some relief. So like I say, ki every stakeholder has to do his own job with honesty. So like police, the investigation has to be completed in the earliest manner possible, so that the charge sheet, or if there is no evidence, a closure report is being filed within a time frame and within a earliest manner possible. And in that case, what happens is, what needs to be done is, in 2006, Honorable Supreme Court of India in a landmark judgment said in that the police has two kind of duties. Number one, investigation. Number two, handling the law and order. And to have the faster justice delivery system, we need to differentiate and we need to demarcate two different police wings handling law and order and investigation separately. Nowadays, what happens is, the police officer who is investigating a case, he is responsible for law and order also. Like what happens is, during the nearby time of Independence Day, Republic Day, these police officers are required for a lot of bandobast and law and order problems. So what happens is, you will see that in courts, 1 week ahead of Independence Day or Republic Day and 1 week after that, no investigation officer turns up to the court. And the ground is that only that we are busy in bandobast and we are busy in law and order problem. So ultimately, because the same person is responsible for law and order and investigation, so the investigation gets suffers because he is busy in law and order. If we'll be having two separate wings for the law and order and investigation, so investigation will go separately, law and order will go separately, because these are two parts of the police duties which are not going to be ended during the lifetime of a police officer. He has to be in law and order. Police की duty law and order की भी है, and their duty is to investigate the case also. So if we can have a specialized wings for investigation and law and order separately, so the investigations will not suffer, the dates will not be taken on the ground that investigation officer is not developed. Secondly, the complainant's part, yes, the duty of complainant is to assist the state prosecutor who is representing his or her case in such an effective manner. He or she should also not be very prejudiced taking his own case. Yes, but they will always be available to assist the public prosecutor, so that the state prosecutor also does not take adjournments or is unable to assist the court about a particular fact or question of law. So if we are there to us, if the complainant victim is there to assist the state prosecutor, so yes, state prosecutor will be are able to present the case in more effective manner, which they sometime I feel they are not able to. Sometime, according to me, accused gets a relief because state was not that good enough, which I personally feel. Thirdly, state prosecutor, obviously the state prosecutor also has to consider from a point of view that being a law officer, he has to be fair to the accused as well as to the court. You present the fact, whatever are in your client's favor, in the victim's favor, but if the facts which are favoring of the accused, you should not distort those facts to the extent that even court takes time to solve that complexity and then give the result. If you present the facts in a simplistic manner, say these facts are in my favor, these facts are in accused's favor, so then even the court will be able to appreciate the differences between those facts and give the judgment. Yes, being an accused, Yes, you have to be before the court every time whenever required, either in person or either through pleader. You should be there. You should represent your case in effective manner. If you have any adversity, you should do more research and try to convince the court that this adverse point against me can be given in my favor. This is the law. You should do more research and assess the court. And yes, ultimately the judge, he needs to be strict in sometimes there's a genuine difficulty that judgments are being given. But yes, because of some frivolous reasons and unexplained reasons, the judge should be strict. They should impose the costs on the parties if they are not turning up, even despite the orders and summons of the courts. So yes, all the stakeholders have to do their duty to the best manner possible. Then only this criminal justice delivery system can be fastened, can be more stronger, and victims will not be afraid of approaching the system. Sometimes victim does not register their complaint because they know आज complaint register करेंगे तो 10 से 20 साल बाद judgment आएगा. They either prefer to lead their life and focus on their other parts of life, and they leave that their case. If you will start delivering the justice in a faster manner possible, every stakeholder will do its duty in an honest manner, so victims will also not be afraid to approach the system.
I mean, this was a very great, very nice angle to look at it, because as a layman, I wouldn't have been able to think like this. You know, as you said, that police is, of course, it's responsible for both investment and law enforcement. So both things cannot go hand in hand. You know, you have to leave something
Absolutely.
sometime, as you said.
And this I'm saying, this is a judgment of 2006. It's not that we have not thought of it. Already
Hmm.
judgment is there, but state machinery are not implementing it properly. In some states are there. If they are there, they are not being implemented properly. And in some states, they are not there at all.
Hmm. Hmm. I mean,
This
that's a
needs to.
whole different session that can be done, especially with a state authority. And I would love to have you on side, on my side there. I'll be your accused. um, all right, great, Tushar. This was a great session so far. Last question that I have for you is uh, is basically in a generic sense that I'd love to ask all the lawyers. Time is money in any profession, and I always say this: in legal, it's most of all. How do you ensure to make the best of your time as a lawyer? If you can give us the points, even the young lawyers can sort of, follow that up.
I agree. Obviously, you have started with the right quote. Time is money, and it's applicable in all professions. Yes, it might be, according to me, may have some importance in legal fraternity much more than the other fields. But yes, time is important everywhere. So what I suggested even during the pandemic also to the interns and to the junior lawyers and to the freshers who are just completed the law and searching for a job and are going to join this fraternity soon. So if I say how I utilize my time the best possible manner, so is that first of all you need to start your day little bit early. I have seen the positive results of starting my day early. By early means, being a lawyer, we are compelled to reach the court by 10, at least 9:30 and 10. These are the basic timings across all India where the courts are being started. But if you can you start your day? I personally start my day at 8 o'clock and sometimes 7:30 also. So what I feel is that in the morning is always been there that in morning you have a more energy, more fresh energy, which we can invest either in reading your files. I have a habit of reading files in morning. I do not believe in late hour studies. I read all my files in the morning. After doing a preparation in the evening, I read all final files for the arguments in the morning. So you start your day a little bit early, plan your day accordingly. So when you see, even you have a half an hour or an hour or 1.5 hour even extra, you'll feel the importance of it. That how much energy and how much time you have been saved by just starting your day a little bit early. So starting your day early is very important. Number one. Number two, sometimes being a lawyer, I have also some days where I do not have any case in the court. Now the challenge is what to do. One thing is you can do your pending work. Obviously, this is the there. But second thing, in a more constructive manner, you can start spending on the time on the reading the new judgments. Prepare your index of judgments, your own personal index of judgments. Prepare a law point. You never know what kind law point you can, a case you can get where the law point you were reading about the judgments, your index of judgments, your legal authorities precedents will be ready by and there. You can immediately give an opinion to client, yes, this is the settled principle of law, you can file this petition and these are the judgments. So spending time, I have seen my senior with whom I have interned and I have done my juniorship with him. Whenever there, like today in Delhi there is a Janmashtami holiday, but still I am sitting in office. I have seen my senior who used to use these holidays for reading the judgments, because in normal days they do not have time apart from reading their case files, their clients file. So they use these holidays for reading the judgments, for doing some more research, or writing an article. You write an article. For example, now I'm planning to write an article on this EDPMLA matter itself. I have already written one article on some family law problem, right? So you read that problem, you try to interpret your views in a form of an article, and give it to some legal journals or newspapers and any publisher who is interested in publishing that. So in that manner, you serve the society also. They'll also get to know that this view is also possible about a particular problem. So when the pandemic, the major problem the interns or the freshers or the junior lawyers has, so we are not getting jobs, or we are online. In online, they were getting offers of online internships, but in online internships they were not getting much work. So I suggested all of them that start reading books, start reading judgments, and if you have not planned, you may plan to go for higher studies. Ultimately, start developing your profile, because unfortunately, yes, the in last 2 years of pandemic, the most of the chambers have not done many hiring because of the less workload and because of other problems. But whenever after 2 years you'll get an opportunity, so every lawyer will definitely ask that what you did in this pandemic. So you have a profile that, sir, I did this research, I wrote this article, or sir, I did this specialized course. Today we have a facility of various institutions which are providing various specialized diploma courses. Like in cybercrime, it's a developing law. We do not have a proper cyber statute in India which deals with the cybercrime, but cybercrime is happening every day. Like people have start thinking about artificial intelligence and law. AI is the new hot potato now these days. So how you can in artificial intelligence, how a law can be implied. For example, one of the seniors gave a very good example to me that which attracted me a lot. They say you think of a problem which is now there also, that a robot driven car is being driven on the road, and because of some technical glitch it commits an accident. So who will be responsible? There is no driver. Can you punish a technology? So you need to think who will be responsible behind that. So there are a lot of problems and issues are going around your atmosphere. You need to just see, be patient. Legal profession requires a lot of patience. So yes, the best manner possible to utilize your time when you do not have you have nothing to do, enhance your knowledge, enhance your research, try to impart that knowledge and research amongst the society. So that will solve your two purposes. Number one, that will increase your intellectual level, and number two, you simultaneously will doing a social service by imparting that knowledge to other people as well. So there cannot be any situation where you are being disappointed that I have nothing to do. I cannot believe in this situation. I personally believe in law there is so much to read, so much to understand, so much to interpret, that you cannot sit idle. So just utilize the time in different manner and believe that you'll be able to do well. Just give time to this profession. This will give you the fruits and you will come up with the flying colors.
I mean, brilliant answers by one. I mean, I thought that I am a lawyer now, and I was thinking why I'm not a lawyer, you know. And I guess talking about, when you also mentioned about increasing or building your profile. You also did your diploma from Harvard Law University, if I'm
Yes,
not
yes, I did that. And I particularly did that in the COVID period itself.
wrong. Mhm.
because we being a lawyers also were not very busy. Whatever online matters were there, we used to do, but I did during the pandemic itself.
I mean, look at you. Doesn't look like there's a holiday in Delhi today. But
Yes,
brilliant, Tushar. This has been a wonderful session. I mean, I just enjoyed it. For my viewers, I just came back from my dentist. My dental doctor was so much to say, but my dentist. And I was not sure that how good I would be, in this session. But your energy came up to me, and this was a brilliant session. So thank you
it
very
was a
much,
great session. I
Tushar,
was
for
very happy with the kind of inputs you brought between and deriving the inputs from my answers. So it shows that because in interactive interviews always are very good for the viewers also and for us also. We also enjoy that. So thank you so much for that.
I really appreciate that, Tushar. Thank you very much. And to formally thank you for appearing today. Thank you so much for sharing such great insights with us. We, of course,
Most
look
welcome.
forward to having a great chat with you again in the future on some other training topics in the international legal industry in coming months or weeks or days. And
Definitely.
for our viewers now, thank you very much again, Tushar. I really appreciate it. I hope our viewers would also love to, witness this session. And finally, to acknowledge our viewers, if you like this session with Mr. Tushar Agarwal, I want you to like this video, to share this video, to click on that red button and subscribe to Click of the Creators YouTube channel to appreciate what we do. And you have more coming in from legal industry leaders like Mr. Tushar Agarwal himself. This was Sagar for Let's Talk World signing off. Thank you very much.